I'd like to welcome our viewers to our program on a series of conversations that we're going to be having with the authors of articles that were published in the Journal of Educational Controversy. The journal is published at the Woodring College of Education here at Western Washington University in the state of Washington. My name is Lorraine Kasperson, and I am the editor of the journal, and I'm delighted to welcome all of our viewers today. One of the goals of the journal is to engage in a more authentic conversation about education and to encourage a deeper discussion with the general public and its legislators, along with parents and teachers and policymakers and other professionals, about the fundamental questions dealing with public schools, the role of public schools in a democratic society, especially a society that is becoming increasingly diverse, increasingly pluralistic. We want to be able to examine some of the tensions, the contradictions, the controversies, the dilemmas that arise in a democratic society, and the role of the public in it. Viewers can read the actual articles by the authors by going to our webpage of the Journal of Educational Controversy. The issue of the journal that we are going to be discussing focuses on a very important issue in this state and across the nation. It has been referred to as the school-to-prison pipeline, and it refers to a national trend in which students are increasingly being pushed out of the public schools and into the juvenile justice system. It is also a problem that has disproportionately affected students of color, students with disabilities, poor students, and also students from other disenfranchised communities. And so it raises for us some very serious questions about this nation's commitment to its youth, to their education, and to social justice and equal treatment. Today, our guest is former Justice Bobby Bridge, who wrote an article for our issue on the school-to-prison pipeline that's entitled, "No Single Source, No Single Solution: Why We Should Broaden Our Perspective of the School-to-Prison Pipeline and Look to the Court in Redirecting Youth from It." It was also co-authored by Lila Curtis and Nicholas Oakley. Justice Bridge served on the Washington Supreme Court from 1999 to 2007. Prior to her tenure on the Supreme Court, she served for 10 years as a King County Superior Court judge, where she was also Chief Juvenile Court Judge for 3 years. Since leaving the court, Justice Bridge has formed a youth advocacy group called the Center for Children and Youth Justice, and we hope to also talk a little bit today about her new center. With me today are my co-interviewers. Professor Daniel Launer is the professor of theater at the Fairhaven College of Interdisciplinary Studies here at Western Washington University, where he served as dean for several years in the 1980s. Dan has also been a longtime member of the ACLU Board of Directors of Washington State, and he is the co-editor for this issue of the school-to-prison pipeline. And Dan will bring a set of legal concerns and questions to the topic. Our second interviewer is Professor John Richardson, who is Professor Emeritus at Western Washington University. And his area of expertise is the field of sociology of education. And so John brings a sociological set of concerns to the topic of the school-to-prison pipeline. John is also the associate editor for the Journal of Educational Controversy. And so I'd like to welcome all of you to our program today. Justice Bridge, I thought we might start by helping our viewers to understand a little bit about what it is we're going to be talking about. What is the school-to-prison pipeline? What does it mean?
It is a phenomenon, and an unfortunately increasing phenomenon, of young people being pushed out of public schools. And once they are pushed out from public schools for a variety of reasons, which we'll get into as we go on with this discussion, I would assume, but we know that they become increasingly at risk for not only poor economic outcomes, which have been obviously very well stated in a lot of journals, a lot of newspaper, for example, you know, what it costs someone who doesn't get a high school diploma, for example, over the course of his or her lifetime and the like, what it costs a community by way of reduced earnings and reduced taxing ability to pay taxes and the like, contributions to the community. But what we're talking about here is the way in which, by being pushed out of school, these young people become increasingly at risk for criminal behavior and getting themselves engaged in the juvenile justice system and ultimately into the adult justice system. And there have been many pieces of research over the course of the past decade for sure, but probably over the last 20 years, which indicate to us that in fact those results are what occurs when someone is pushed out of school, ultimately does not receive a diploma.
I noticed that in your paper, even though you mentioned that there are many factors contributing to the school-to-prison pipeline, the one that you have chosen to focus on is the issue of truancy and excessive absenteeism from school. Why did you focus on that topic in your paper, and how does truancy contribute to the school-to-prison pipeline?
Well, fundamentally because I believe that the discussion to date has really been focused on not necessarily the wrong end. It's an important part of the numerous conflicting issues that make up the components of the school-to-prison pipeline. But it really is that part of the pipeline where many warning signs have already been ignored. And a child is a lot further into that pipeline when we start focusing on the issues of concern that we usually talk about in the school-to-prison pipeline than we could be if we started to concentrate on truancy. And here's what I mean by that. In our focus on school-to-prison pipeline in the recent past, in the past 2 or 3 years, we really focused on issues of school discipline, zero tolerance policies which lead to school discipline and ultimately suspension and expulsion from school. We've also focused on the increased, again because of the Columbine phenomenon, for example, concerns for school safety, the increasing use of law enforcement personnel in school buildings. Creating, one would argue, and actually can be demonstrated in research, an increased opportunity for what would ordinarily be minor disputes or conflicts that might arise in a school setting, not to be resolved by the vice principal or the principal or school personnel in general, but an immediate response to call the police and engage it as, or define it therefore as an issue for public safety as opposed to something that could be resolved in the normal setting of school. Criminalizing conduct that wasn't criminalized before. That has been a focus, and it is absolutely important and imperative that we do that, particularly because it leads to increasing what we already know in our criminal justice and juvenile justice systems are huge disproportionalities from the standpoint of kids of color, kids who have been involved in the foster care system, and the like. However, that's an intervention orientation that, while I certainly applaud raising our level of concern about, when we take a look at a little deeper, what we know is that warning signs, the same kinds of warning signs about disengagement in school, and that's really what we're talking about, pushing kids out of school, subjecting them to out-of-school suspensions, for example, begins a phenomenon of disengagement from the educational process in the young person, even before they begin to, or if they do, fall prey to the engagement in the juvenile justice system. So for a while there's an opportunity to call that back, to try to re-engage the young person in school. And by doing that, and you can do that before expulsions and suspensions have operated, you can do it by looking at a couple of warning signs. The warning signs being beginning to be a failure in school in some core courses, but most appropriately for this discussion, absenteeism. Kids are voting with their feet, as it were. They're not understanding. They have the issues in their family. There are community issues that combine and cause them not to want to go to school. All of these various factors that are coming into play really result in absenteeism, and that's our earliest and best, I would argue, warning sign. And that's when we really need to pay attention, not after the kid is further along into this, what we know now is a pipeline.
I know that in your paper you talk about how the court can become a leader in this field, and about different kinds of reforms that you recommend. I thought before we talk a little bit about the reforms, yesterday I asked some parents, what do you know about the truancy policy in your school? And most parents know nothing about it. One said to me, well, it was probably in some packet that I received in the beginning of the year, but I don't know very much about it. Perhaps it might be helpful for our viewers if you could just talk a little bit about the Washington State truancy laws and statutes, and what are they? What are the procedures?
Well, Washington State has one of the more prescriptive statutes relating to failure to attend school. It's an old statute, but it's the prescriptive part, and what we live under, the processes that we live under now, are from the 1995 statute, which bore the name of a young woman called Rebecca Hedman, the so-called Becca Law. And the Becca laws incorporate not just truancy, but also at-risk youth, some proceedings for at-risk youth in general. Kids who are running away from home, kids who are having serious difficulties in their homes. There's an opportunity for parents to bring various petitions to the court in order to seek some court involvement in resolving the issues in the family when all else has failed. And there are certain screenings that all else must have been shown to have failed. But in truancy, another area, because of we knew at-risk youth demonstrate the fact that they are on track to become more seriously involved in negative outcomes for themselves if they stop coming to school. We know, for example, that research has shown that if kids stop coming to school, they're at much higher rates at risk, not only of criminal engagement in criminal conduct, but also of substance abuse, of suffering from undetected mental health issues, somatic complaints which also go undetected, all because they're essentially disengaging themselves from, their major community as young people, which is the school system. So that and a lot of other factors inspired the legislature to pass the Becca Law and to say that we were going to pay attention to kids who were not coming to school. And the stage was set, the threshold was set at looking at children who have, even from their very first absence, there is a requirement on the part of the school to contact the parent and find out, inquire what was the reason for the absence. Within 2 absences, the school is required to engage the parents in a conference, again, as to how the school can be helpful to bring the child back to school. Then, if there are 5 absences within a month or more than 10 within a school year, the school is obligated, if the other situations have not, or the other engagements have not resolved the absenteeism, the school is required to file a petition. That petition is a petition in court, and the petition seeks the court's assistance in, first of all, declaring that this child is subject to the Becca Law, that they are, by definition, truant because the requisite number of absences have occurred, and look to an order from the court to return to school, and an order to the school to say, here's what kinds of solutions need to be looked at in order to re-engage this child into school. The problem with that, of course, is that it immediately gets the court involved in an adversarial position, the school district versus the parent and the child. The child is always named as a party. The parent need not be. The practice for most districts in the state of Washington do, in fact, also name the parent, but also the practice is that in most courts around the state, the parent is rarely engaged as a party, at least in the formal court process, which is unfortunate. And courts began to see that this was not the way that we were going to get kids most effectively re-engaged in school. The statute has been amended a couple of times in order to provide more leeway to courts to withhold, the legal term is stay, but to withhold any further court involvement pending the opportunity for the school and the parents and the community to whatever community resources may be brought to bear to come together to try to resolve the issues themselves without getting into this formal process. The statute also, some years ago, added specifically a way to divert, again, it's a legal terminology, meaning to divert the child from the formal court process. This diversion would be a community truancy board that is specifically called out as one of the ways in which the court can give the school and the child and the family an opportunity to resolve the issues, again, without getting into the formal process. It's always been the intent of the statute that the court was to be the place of last resort. Now we know by research and outcome data that that is as it should be, because the court process itself is the least effective and arguably the most likely to result in more negative outcomes for the child than any of the other options that we try to explore. What I'm trying to do in this paper, and what we have been doing through the Models for Change initiative in the state of Washington, is to demonstrate that there are in fact other ways in which the court can assist in providing accountability of all the parties to ensure that the absenteeism is resolved and that the child once again goes back to school, but can do it in a way which is in a problem-solving mode, in a leadership and collaborative mode, as opposed to the more traditional process of the court holding a hearing in an adversarial environment.
I do have one question, though, about the formal process before we go into the reforms that you're recommending. You argue that the courts can become a place to resolve these issues and can take a leadership role. There was a case that came down by the Washington State Supreme Court. I think it was just last year. It was after, of course, you left the court. It was Bellevue School District versus ES. And the ACLU and other groups were very concerned about the fact that young children really are who go before the truancy court during the initial fact-finding hearing. They have no representation. They have no right to legal representation. And yet, at that initial hearing, they are asked to agree to things which have consequences for them. And they may not understand the proceedings. They may be intimidated by the proceedings. And yet they're told that they have a right to present their evidence, to give, bring witnesses, to question the school representative, and question their evidence, and yet all of this without legal representation. Once, of course, that they enter into an agreement, then they can be held in contempt of court and face even juvenile detention as a sanction. And yet, even though the Court of Appeals ruled in favor of the student, the Supreme Court overturned it. And I have a quote here. They said, the issues that are before the court on the initial hearing, at an initial hearing on a truancy petition are uncomplicated and straightforward. I don't think they're that uncomplicated and straightforward for the child who is there alone trying to defend himself or herself. I was wondering, what is your take about that decision that came down last year?
Well, I certainly wouldn't want to argue with my former colleagues, but it was based upon, I think, a long line of cases. First of all, that long line of cases relating to when the right to counsel attaches. In this particular process, unlike a lot of other states, I might add, the process for truancy here in the state of Washington is a civil matter. It's not a criminal matter. And so that would be the first rationale for saying there's no absolute right to counsel in a civil proceeding, and there isn't. And so there's a long line of cases, and once you get into that analogy, that's the road you can go down. The court did talk about the question of what was being decided in that preliminary hearing. It does vary from jurisdiction to jurisdiction, but for the most part, that preliminary hearing is to only resolve one issue, and that is whether or not the child's absences have met the statutory threshold. This is why the court referred to it as a relatively simple determination, factual determination. And in most jurisdictions in this state as well, the school district is not represented by a lawyer either. It is the school district representative who is the truancy liaison. At least that's the practice in King County. In other portions of the state, it's an actual school administrative official as opposed to someone who is actually doing truancy solely, specializing in truancy. And the order that results is no more complicated, and use the terms advisedly, than to say you must go back to school. And if you don't go back to school, then you are subject to contempt. And at the time of the contempt proceeding is when the child is entitled to a lawyer. Because at that point, there are options for the court to, as you indicated, perhaps be sanctioned to detention, although that is used fairly infrequently in the state of Washington. I would argue not enough, but certainly infrequently. And there are other things that might be ordered, including engagement in services at the time of the contempt proceeding. But it is at that point when, as the court saw it, at that point it begins to look, since there is a penalty involved, which can be can be incarceration, that is when the right to counsel, even though this is a civil proceeding, would kick in.
Do you agree with it?
I don't think that detention should be used for truant students. I think that we have so many other alternatives now which are available. I think that what we're really trying to do is to avoid a court hearing at all, which is what a lot of these various counties, court jurisdictions in the state of Washington have been experimenting with over the past, well, let's see, probably once they began their initial research and determined where their baseline demographics were and processes were, to now, probably they've been involved for about 3 years, and we have good evaluations coming out of the work that they've done in order to avoid having the children even at an initial hearing. So I think that's really where the emphasis needs to be placed. Do I agree or disagree that they should be entitled to counsel at the beginning? I don't know. I think that if we do keep it to, as I described it, which most jurisdictions do, where it really is almost a rudimentary decision as to, is this the attendance record, and here's the school district representative, that probably the right to counsel does not need to attach. Would it be better if they have lawyers, and they do in some counties in this state? Probably, but the reason why it would be better, in my opinion, is that it's more likely to resolve itself at that stage by having the lawyer act as a mediator instead of the judge being placed in a mediator's role at the time of a formal hearing, so that they, in the proverbial hallway outside the courtroom, the school and the parents and the child are coming together to alleviate the absenteeism. By definition, remember, the petition filing itself and the having of a hearing as a result of that petition filing is only happening because the school has been unable either to locate the parent or to find out what's really happening with the parent and the child that has resulted in an absenteeism.
I'd like to turn to my co-interviewers now and have them engage in our conversation. Dan, do you want to raise any issues?
Yeah, I was interested in the part of your article, Justice Bridge, which talks about the stages that the court can use to help alleviate the situation. One is, and you can help me understand exactly where in the process these are keyed in, because I'm not sure I remember too accurately, but the first stage has to do with an information session that the student and parents are sent to get information about how to avoid truancy. Mm-hmm. And the second one, if that fails, is a session with a truancy specialist, which I take it is one-to-one with the student. And the third session is a mentor. Mm-hmm. The third step is a mentor. And I was intrigued by this process because one of the things that seemed to me to be prevalent in so many of the steps that are more common in the STPP scholarship, so many of the phenomena that are involved in the causes of students falling into the school-to-prison pipeline. Part of the problem seems to be that there's very little opportunity to really hear the child. Mm-hmm. And those opportunities where the child can be heard are tough for the child to take advantage of because the child is intimidated or doesn't know how to frame his or her own problem, or
or is only asked yes or no questions.
Yeah, well, and doesn't know what will happen when he or she returns to school, and the kids ask questions about what went on. And so whatever the complications of the child's situation are hard to get from the child. I guess my question from all of this is what in the process enables the court to, in the process as you understand it and are trying to advocate, allows us to hear from the child, allows the child to articulate in some way what the problem is and help the caregivers craft a solution for them and lend support which is meaningful and helpful.
You're so right. The critical voice is the child's voice, without a doubt. The second most critical voice is the family's voice. Again, the paper goes in at some length, although at some length, about the extent to which the family's role in either having a child believe that school is an important place for him or her to be or not. It really begins at home and the kind of supports that he or she receives there. So those two voices are paramount, in my opinion. I think what you're describing is the Clark County process, the Truancy Court project in Clark County, which really does allow for a lot of opportunity outside of the court for individuals to talk to one another and to try to resolve the issues, to try to find what's really going on with this child. We know, for example, from research that was done in Clark County, that when they started using an assessment tool for kids who were who were identified as being truant by virtue of having a petition filed, so hence the court had jurisdiction. An assessment was administered to them, which was a basically baseline mental health assessment, and found that these children were experiencing more symptomatology of significant mental health issues than the kids who were coming in to the same court by virtue of a juvenile delinquency petition. And so we know that there are troubles.
The Mazie instrument?
The Mazie, exactly. And that was a real eye-opener, not just to Clark County, but to folks all around the state with whom it has now been shared, to say, you know, these are not, to the extent you thought so at any point in time, these are not cavalier absences that are happening when children reach the level of absences that allow a court, or I'm sorry, allow a school, require a school indeed, to file a petition. There are significant issues, some of which are mental health and orientation, others of which you know, maybe have other reasons for the behavior. So where the court comes in Clark County, for example, is first of all as a convener in developing these kinds of systems or alternative to the regular system, to convene the major players and say, look, we've got to do better. Here are what these kids look like in our community. They are troubled, they need resources. Parents often do not have either the understanding or the resources to be a powerful advocate for their own children. The schools lack resources. We need to come together and bring service providers in the community together and figure out what would be a good triaging, if you will, to be able to, first of all, discern what really is behind the absenteeism, what supports the family needs in order to ensure that the child may come back to school. There are just almost as many reasons as there are children, but they cluster around issues having to do with, first of all, parents not being aware of the obligation, parents themselves who had limited education and really don't understand why education is important, even if all you are concerned about, and again I use that term advisedly, even if what you're concerned about is the economic circumstances of the family, schooling is so important in order to improve those economic circumstances. You know, that argument, that information needs to be made aware to the parent. The parent may not be English speaking. The parent may have concerns for, well, have a need for the child to stay home to take care of a younger sibling in order for the parents themselves to work to allow the family to survive. Multitudes of reasons. The child may be afraid. There may be gang infestation in the community, and he or she is scared to even walk to school or scared to be at school because he's being bullied. For all kinds of information. That's very complicated. That doesn't come out in a court hearing. It doesn't lead itself to sort of the typical adversarial system. So what the Clark County Court is doing in partnership with its educational service district as co-leaders, if you will, brought people together, including parents and children who had been through this process, so young people by that time instead of children, youth, to talk about their experiences and what might make a difference. How could we have found out earlier what these issues were and provided the proper kind of support rather than bringing you to court in the first instance? And so they came up with, first of all, what you were describing as a workshop, which now happens in many of the counties. It happens in virtually all of the counties that are working under Models for Change, but also is being adopted and adapted in various other counties where folks come together who are at risk. This can be pre-petition or it can be post-petition, but parents and children who are at risk of either being on the eligibility list for filing of a petition or who are already there can just learn about this process, what the law says, as Lorraine had asked, what the law says about their obligation to go to school, and then what some of these consequences are, what some of these negative consequences are for children who do not go to school. And that includes the economic, but it also includes the social and other kinds of impacts and risks that they are subject to based upon the fact that they are not engaged in school and in a school program. Somewhere in the neighborhood, depending upon the county, between 60 and 70% of the kids and their parents who come to these kinds of workshops return to school and and are successfully re-engaged in their schoolwork. One of the other features I should add to this workshop that you didn't mention is not just a learning about the process and learning about the negative consequences of not resolving this excessive absenteeism, but they also have an opportunity to sit down and talk to one another. And a school representative and the child, in some instances we're using peer mediators, so actually the child is talking to someone who is a near peer, someone who is a little bit older, sometimes a teenager, but most likely a college student, who can talk to this young person to try to hear the voice of the young person as to why they are missing school. Some of that, it's up to the child whether that gets brought back to the table in the mediated process. But for the most part, kids are very open. Once they are provided an opportunity to discuss it with somebody with whom they feel comfortable and they have a trusting relationship with, it works amazingly so. And the child and the family and then the school representative come together, either with an adult mediator or with a continuation of having the peer mediator, and they resolve themselves there to work on an agreement where everybody has a role. The student agrees to go back to school. The school, now having heard that there is for example, significant conflict between this child and another student who he's in class with, let's remove him from that situation, see if we can't shore up some supports there. This is an example. The school agrees to do that. The parent agrees that they will do whatever they can to ensure that the child goes to school. We're talking for the most part now about middle school and high school age kids for the most part who are the subject of truancy petitions. Some would argue that it should be younger, but let's not get off on that right now. So that where the parent is basically saying, I will do my best. I will help whatever, if he needs an alarm clock, if whatever he needs, this is what I will contribute to this situation. So everyone is held accountable. It isn't all focused on the child. Certainly the positive outcomes we're searched for is a focus on the child, but everybody is responsible. And off they go. And then if that doesn't work, if the absenteeism persists, perhaps we haven't gotten to what's really going on. Or perhaps the services, if there in fact were services discussed, perhaps they were not availed of. There were transportation issues, or there was a long waiting list. I mean, the list can go on. But then get to the next level. We're a community truancy board. 2, 3 people, usually 3 or 4 people who come together again to have a bolstering of the situation, to let these families and the child know that the community is there to help. What can we do to ensure, these things were supposed to happen, why didn't they? What else can we do here? And then finally, when that doesn't work, again, a more one-on-one specialist who not only can hopefully ensure that by this time almost 100% of the time you would have some services which are needed. Why is it that these services are not being engaged? How can we help? Is it a matter of driving you to an appointment? Is it a matter that we need to advocate for you to get to the top of the line in this particular community-based organization? What can we do to make sure that that the child gets back in school? But it's levels of intensity frequently. In the meantime, the court is there to receive reports, to perhaps act as its own kind of mediator if that seems to be necessary, because the court can then be engaged in a problem-solving activity, which is more and more frequent now with our drug courts and other kinds of reforms that we've done in order to make the court more effective than just in an adversarial process. So the court is there to hold people accountable if necessary, but the formal court process has not been engaged. Nobody's going to a hearing. Nobody is in need of a lawyer, and yet hopefully the work is being done. And these are varying kinds of experiments that have been going on in changing of the process around this state. And Clark County is a prime example of a great success as a result of doing things differently.
Well, who is on the Community Truancy Board, and what authority do they have?
It's all voluntary, of course, as most diversion programs are,
Yeah.
by the way. But That varies as well. In Clark County, typically their community truancy boards consist of someone from the school. It doesn't necessarily, it could be a classroom teacher. It might be the classroom teacher for one of the children, but maybe not. Because typically these boards will hear, 2, maybe 3 cases in a session. So, and the sessions may be every week, twice a month, again, depending upon the jurisdiction. But typically there will be somebody with an education background. So, typically there will be someone with a mental health background. If there appears to be an indication of substance abuse or some other kinds of issue of that, whatever that might be, a learning disability, whatever, a person in that capacity as well. And then a person who is a parent, an interested party who loves kids and wants to help kids, retirees, retired professionals, all of the above are utilized in these community truancy boards. And they have been developed to mimic community boards, which have been used for a very long time in this state on the juvenile delinquency side for minor offenses. Youth in this state, who now we're talking about offenses, but for minor offenses, on at least two occasions, a child will have an opportunity to go to a board, a community accountability board is what they're usually called, CABs. And those boards are made up of just the same kind of folks that we discussed for the Community Truancy Board, and are hugely successful. 95% of the kids who go before those community accountability boards, or whatever they may be called in the local jurisdiction, never again commit an offense, return to successful and productive lives. So we weren't sort of making this up. We were trying to take a model which we knew worked in a different kind of setting, arguably an even more difficult setting, because there we were talking about a child who had engaged in criminal conduct, and with truancy we're not at that stage yet, and so we thought if it works for this level of behavior, maybe it can work in the truancy setting, and it certainly has been great.
Mm. And so, if the truancy board talks with the child and the parents, and are other people called in, like other agencies that have helped, that were supposed to be involved in the coordination of what shall we say, care that was devised in the first stage of the process?
Typically not, but some boards do. Again, at the parents and child have to agree to this kind of a process, but they can act as overseers. They can say, we'd like to hear from you in a week and see whether or not Agency X has done the initial screening, that they've accepted you, et cetera. The conversation is really limited to the parent and to the child.
Okay.
Because otherwise it's beginning to smack of a more formal proceeding, and you might as well have a judge there. But it depends. In Spokane, which it makes great use of community truancy boards, they have not yet adopted their workshop as a first sort of screen. But they are making great use of community truancy boards in virtually all of their districts now in Spokane County. I think there's a few remaining who still don't have boards per se, but they not infrequently, their boards not infrequently seek to have some oversight so that they are monitoring the progress, and again not have to involve the court, because they are taking that responsibility on themselves to monitor the progress. Time is of the essence here. I mean, there was a reason for 5 absences and 10 absences as being a threshold. Every day that a child is absent from school, particularly at the middle school and high school level that this is focused on, really results in more and more likelihood that they're going to be failing in a core course, that they will be developing attitudinal issues, I guess, so that school becomes more and more of a remote place. It's kind of like the self-fulfilling hypothesis that, I don't want to go there because I'll be embarrassed to go back because I've missed so much school, and yet it just keeps escalating. And then for some districts, for most districts, once you miss a certain number of days, you are no longer eligible to get credit for that class. And so then you say to yourself as a child, well, why should I go back? I'm not going to get credit anyway. I might as well just drop out. So you see the slippery slope we get on. So time is of the essence. And even though the courts are, in these, in my opinion, these reforms, the courts are stepping back and saying, we're not going to require you to come to court. We're not going to require you to provide us specific reports on a specific child. We are going to leave it to you, but we're going to have a certain amount of faith and trust based upon the process that we've gone through to develop this new system. We're going to have a certain amount of faith and trust that you are in fact being accountable, and that if these mechanisms that you're using in order to get the child engaged are not working, then try something different and try something different again. But at the most, you have to tell us when you need us, because we can't afford to have the child miss any more school and get to the dropout stage.
I've been thinking along two lines while working through my thinking about the school to prison pipeline. One line is what I'll call the counterfactual line, which would be show me the evidence that there is a pipeline. Show me the evidence to support the use of the word cause. Why wouldn't kids be destined for incarceration anyway? And whether they were suspended or not, or given any kind of number of
Did I say cause?
No.
Okay.
We'll refer to some fictitious.
All right.
My thinking along that lines is that the very phrase "school to prison pipeline" contains two elements. One is causality, school to prison, so therefore it's already there. School causes prison. Pipeline. It's an imagery. The second one is the word pipeline, is that there is a flow of effects that accumulate and so forth. So in fact, the research is already set up, what we observe, how we observe it, how we interpret it, and so forth. But I really yet have not found research that I would really hold up in high regard that acknowledges the contamination, let's say, of certain things we call fallacies, the ecological fallacy. You can have correlations between suspension rates and incarceration rates, but it's a spurious correlation. And you can't, but we make inferences about individual behavior and so forth. The second line of thinking has to do with that I might say nothing has really changed in the last 100+ years. When I hear your emphasis on truancy, which my mind immediately thinks of the use of the term stubborn children at the turn of the century. So it's always been around. There have been various ways in which we describe the absence from school and so forth. So all that said, I'm kind of like advertising myself as a cautious cynic here. So let me get right to a question. If a hypothetical situation, a child is gone from school for X number of days, I don't know, something like that, and they're brought in. I heard you say that there were a multiplicity of reasons for why they are truant. My sociological contaminated mind immediately thinks, no, there aren't. There's never any multiplicity of anything. There's always about 3 or 4. So let's say we focus just on that initial, which I completely agree, that initial micro situation where before they enter the pipeline is some kind of notion, but we focus on the truant point. I'm inclined to expect eminently reasonable, rationally thought out, ethnically oriented commands to not go to school. I think of research on called the schooling penalty, that the child knows that the more they go to school, the longer they stay in school, the lower their income. And in fact, they're empirically correct. So my question is, what do they say? What do we learn? There are reasons for why they're not in school. And can we get any more definitive than multiplicity? And what would they be? Has there been any research on trying to reduce from multiplicity down to 4 recurring reasons why, and they're eminently reasonable? That's what I'd love to know.
Mm-hmm. Well, you've raised a lot of issues. Let me see if I can sort that out.
What's the evidence on why they're not in school?
Well, research done just in the context of the Models for Change initiative here in the state of Washington, done by Washington State University, primarily focusing on Benton Franklin counties. And then additional research that's been done by Dr. Tom George from the Administrative Office of the Courts here in the state of Washington, based upon the results of his assessment tool that he developed, which is now, it's the WARNS, the risk and needs of student absenteeism, Washington absenteeism, really do focus on particular issues relating to school failure, which again is a kind of maybe perhaps circular, but perhaps not, that the child does not feel successful in school and begins to retreat from that lack of success. And in particular, it's really doesn't look to all classes in school, all of the curriculum, but particularly the core areas of reading, writing, arithmetic sort of thing, where, and this begins to happen at a young age, which is why I was indicating earlier that some would argue that we are overly focused on middle school and high school, and we really ought to be looking at elementary school, where these patterns of, if you will, disengagement, which is different from truancy, but it's, it's a beginning of a pattern of sort of phasing yourself out of the school community and the whole education environment. That certainly is one. And then there are, beyond that, elements that relate to family circumstances, which is a key component, and that is why the involvement of the family in the solution is so critical, and why if the school is not able to connect with the family, or if the court is not able to have the family become involved, it's a virtual prescription for failure. The family has to be supportive of the child attending school, and to do whatever it needs to do to try to get whatever supports it needs in order to permit the child to come to school. So that would be a second one. A third major element has to do with mental health concerns. There are depression, anxiety, those kinds of diagnosable mental health issues that are found to be in excessive, an indicator of a reason for excessive absenteeism. And then once you get beyond those 3 main areas, and I guess learning disabilities happens to be another one, but that is really more attached to the school failure and the feeling of a sense of, that's more of the school failure is sometimes related to a child who has a learning disability that's been undetected kind of thing. It can also relate to the mental health issue, I guess. But those are the key factors that the research that we've done here in the state of Washington indicate are what is occurring in our truant population. Now, I sat on truancy cases right after the law took effect in 1995. It helped to develop the early systems that we used between 95, 6, and 7 for truancy cases in King County. And I did hear a multiplicity of issues from these kids. And some of them were as simple, or at least superficially simple. Now, I would see them once, and then they would, if they went back to school, I never saw them again. it was as simple as, I'm too tired and I can't get up in the morning. Well, there's something else going on there, but I take that as, you know, at face value and say, what can we do to help? And so we talk in some very mundane terms, because I can remember it as though it was were yesterday, about, well, we'll get an alarm clock, and how about if we have someone call you, and then would you really do that? And then they get all kind of perked up. And say, sure, I will. And sometimes that works and sometimes it doesn't. But what I think has happened, you know, practicing psychology without a license, is that the child knows somebody cares and somebody's watching. And so therefore, you know, I'm really interested that you go to school, and so I'm going to go to school. But then we get some kids who would be crying because they're so afraid because they're being bullied. And you know, at that point, it's not me as the judge who is certainly the person able to resolve this, but it is certainly get the school counselor involved, get the school, whatever part of the school administration needs to be aware of this, and try to get them at the school level to create the kind of climate and the kind of safety and security that this child needs to feel so that he or she can safely go to school. And frankly, if they can't satisfy that at the school level, then they ought to be making arrangements to have the child within the district go to another school. And we had all of the above happen in the context of a court hearing. The problem, or not the problem, but the point
in the context of a court hearing.
Well, because these are, I'm hearing this now. These are my examples of kids coming before me. What I'm saying is that that was a part of my learning of, why should this be happening at the court level? And why can't these same conversations be had if the school, either for whatever reason, cannot do it by itself? And I think there are a variety of reasons. I won't say multiplicity. There's a variety of reasons why the school isn't able to conduct those kinds of conversations on their own. For one thing, they don't have necessarily folks who know about the resources that are available in the community if it is a community-wide problem, or what options might be available in another school if it's within a district, you know, all of these kinds of questions. So the team that needs to come together can best be facilitated by either a school district personnel, or like in King County, a team is facilitated by the prosecuting attorney's office, who doesn't appear in truancy cases until and unless there's a contempt. But in each community, or it could be the court. And the idea is that this conversation that I was having at the very expensive and adversarial setting of the courthouse doesn't need to happen in that expensive setting. They can have it at a community truancy board level, et cetera.
Okay, can I, real quickly? One of the...
We have just a few minutes left.
Oh,
Okay, because I want to go back to your I didn't say, I don't think that the school to prison pipeline, if it is stated as causal, that it should be, because I don't think it is.
No, it is not.
I do, right.
Absolutely
I do
right.
think that, though, however, that there are legitimate correlations between kids who are truant, kids who are disengaged in school, kids who drop out of school, and these other kinds of failures in life. And, you know, the statistics that I never remember, but you know, about the number of prison inmates who've dropped out of school and the like. Not causality, and not that there aren't other risk factors, but school is a risk factor.
But it always has been in many ways. So
that doesn't mean that we've solved it.
oh God, no.
Well,
no,
right.
Absolutely not. No, no.
So we've slapped a label on it.
One of the more powerful studies I've ever read in my career, let's say, is when a black kid, young black kids, told her to take an IQ test, and they freak out. But they said, but you tell me. They said to the kid, you tell me when you want to take it, and in the meantime, you don't have to sit in a chair. You can do it on the floor, and you can eat Cheetos. When they set up those circumstances, the race differential disparity in IQ was erased. My question, again, is, do the kids who come to these before any court hearing, do they know that they have been, in a way, labeled truant? Do they know it has to do with truancy? And so what are the actual physical circumstances of the room? What I'm hearing is a lot of the official line. There's this and this and this, all the language and so forth. But the kids are looking up at this barrage of rules and people. I don't know. What does it look like?
Not necessarily. They're certainly not looking up at anybody until they get into court. and even then it depends upon how the court's, sitting. But the idea is for it to be a caring community that is working with this child to listen to the child.
I understand that, but does the child see it as a caring situation?
Well, we haven't done surveys on how the child sees it, which would be a great idea to do that. We do take surveys from kids about the workshop process, as a part of the qualitative evaluation of these workshops. Those are the first cut, the broadest number of people, and they're very complimentary from the standpoint of the kids. I felt that somebody was listening to me. I felt I was able to articulate my issues with the school, with the teacher, with whatever, fill in the blank was about. The parents, similarly, had very positive things to say about, this was the first time I felt like I had an equal voice to the school teacher, or I'm sorry, to the school representative. They weren't things like they weren't lecturing me. This was a conversation. I'm paraphrasing, obviously, but we are getting from, and that includes workshops that are held in Clark County and King County. I mean, very diverse, Benton, Franklin, very diverse places. We're getting generally positive experiences that way.
Great.
Well, this hour has gone very fast.
It sure has.
We have so much more to talk about. I'd like to thank our guests, Justice Bobby Bridge, and our co-interviewers, Dan Lahner and John Richardson, for joining me today. You can read Justice Bridge's article in the Journal of Educational Controversy. Come and join us as we continue our conversations in the future. Thank you again.